Hi, Seth. We're live.
Yeah, you're saying that loudly because I was just cursing at you.
You you were being real mean.
Well, you started it.
I don't even want to. I don't even want to
Doesn't sound like
relitigate
we're like
that.
talking to our
No,
mothers.
not You're right. It makes me so mad when you do that, Mom. We are. This is the last recording and live stream of our 2024 broadcast year. The next time we live stream will be in the new year. So thank you, those who have turned up for the live stream over the past, since we started doing this a few months ago. Again, if you have questions, wherever you are, Facebook, LinkedIn, or YouTube, feel free to ask those questions live, and we will do our best to answer them on the show. Let's do it.
I'm excited.
Welcome to How to Split a Toaster, a divorce podcast about saving your relationships from True Story FM. Today, what do you do when your toaster gets burnt? You cool off in mediation.
Welcome to the show, everybody. I'm Seth Nelson, and as always, I'm here with my good friend Pete Wright. Today, we're going to talk about preparation. You got to prepare for mediation. Otherwise, you're going to waste a lot of time, money, have a lot of frustrations. You can only control you, so you got to be prepared, and you can't make the other side be prepared. So that's going to be one of the many takeaways for today.
Okay. I would like to start with, and we should set the table for this, because the next episode is we're actually speaking to a fantastic mediator, Tammy Spar, about the mediation process. So today we're gating this conversation to the stuff you do with your clients to prepare them to have a good mediation experience. So to open up, how do you set realistic expectations for your clients? Let them know what they're in for.
Yeah. So we start talking about mediation very early on when we're representing a client, because from day one, we're always talking about what are the goals? How are we going to get there? And people will ask, well, what is mediation? Do I have to have a lawyer to go to mediation? No, you don't have to. Not in Florida, not in any state, to my knowledge. Well, what's going to happen at mediation? And here's what happens, because to understand what is going to happen allows you to then prepare for what will happen. So one, the goal of mediation is to get your case resolved, or as much of your case resolved, including any substantive issues or any procedural issues. That's the goal. So how do we achieve that goal when we're sitting there in a room with you and your lawyer, and the other party should be in the other room with their lawyer, and the mediator or neutral, who is not a decision maker? You have to understand that. Not a decision maker. Tammy will talk about that next week, where she has no dog in this fight.
Right. She's not a judge. She's okay. Here's a sidebar, counselor. How legal is a mediation procedure? There are lawyers there and a mediator there. Is this a thing that is somehow part of the court process, or is it just a completely independent exercise?
It's part of the court process, in that the court will order you to mediation before you can go to a trial.
Okay.
Sometimes if you even have a temporary relief where you want to get into court, and then you will have to go to a mediation before the court will make certain decisions. Okay. Other motions, you might not need to have to go to mediation first.
Got it.
So, but there's no record. There's no stenographer or court reporter that you see in the movies, because it's all confidential.
Okay.
Everything in mediation is confidential. And the reason that it's confidential, there's always exceptions to the rules, which we're not going to bother with today, is because you want to put your best foot forward and try to resolve the case. So if I say to you, Pete, we're arguing about $100,000, and I say, Pete, I'll pay you 75, and you're like, nope, I want 95. And then I go to court and I say, Judge, Pete doesn't deserve any. It should be 0. You don't get to say, but at mediation, he was going to give me 75.
Okay.
Like, doesn't happen. Okay. So that's kind of now the only things coming out of mediation are going to be a mediated report, which is just a fancy term for, I'm going to tell the judge whether you resolved your case or not and who was there. That's it. So the judge,
if it was resolved,
that will end up in the court file.
Got it. Okay.
Okay. So that's the legality part of it and
Yeah.
what it happens in the court file. Other than that, you're going to be in one room, they'll be in another. Mediator goes back and forth.
And they're never in the same room, the
They,
parties.
very, very rarely. And I always advise against it
Okay.
because the power struggles, the emotion, one roll of the eyes, the whole thing goes south.
Okay.
So then sometimes the mediator will bring the lawyers together to like move it along. Like, hey, I'm in a long jam. It's quicker to let's see if we can talk this through. Clients are still the decision makers.
Mm-hmm.
So go talk to your clients and see if they'll agree. And if not, they won't. And it's not that we're like being all secretive. We say we're going to go talk to the mediator to see where the roadblocks is and try to brainstorm this in a quicker fashion.
Sure.
Okay. So what gets discussed at mediation? This is going to be shocking to you, Pete. The parenting plan, equitable distribution, alimony, child support, attorney's fees, and costs. Yeah. Okay.
Got it.
So how do you prepare for a parenting plan mediation? You draft a parenting plan before you get to mediation.
Okay. So you're coming in with what you're proposing as a solid parenting plan from your perspective, your client's perspective.
Not only am I doing that, if we're doing it to the best of our ability, we're sending that parenting plan over to the other side before we ever get to mediation.
Okay.
Because then I walk in and I hand Tammy a parenting plan and I forward it to her in Word and I say, we sent this 4 weeks ago. We haven't gotten a response. So where are we?
Best case scenario, you've swapped parenting plans.
Best
party to party
scenario.
Yeah.
I've sent that 4 weeks ago. Within the week, they sent me back a red line version. I've edited it, accepted changes, sent something, and we're like in the process.
Mm-hmm.
Okay. Best case scenario.
Got it.
Let's say that there's just some issues in this case that are very difficult. We've talked about them on the show many times.
Yeah.
Someone dealing with mental illness or suffering from some sort of addiction issues, or is not just in the right place mentally to settle the parenting issue. And what I mean by that is they've been the stay-at-home mom. They've been raising the kids. The kids are 6 and 4. Everyone says she's a great mom. There's no debating that. But she just can't wrap her head around not seeing her kids for 2 days.
Yeah.
Right? Legitimate concern.
Yeah.
And maybe she's not even bashing dad. Like, yeah, when he's with them, they're good. He's just not with them a lot because I do the majority of the parenting.
Yeah. Right.
Okay. So you might not be emotionally ready to settle that case. So sometimes what we do is when we're doing that, look at that, sneaking in the back. You see that? I know.
It's so quiet too.
Yeah, I know. But he's driving his briefcase. He's leaving at 4:12.
He's like
Get
the
out of
Pink
here,
Panther.
Right. Exactly. So listen, you might not be there. And so then the parent might say, I want to do a step-up plan. Like for the next month, dad could have every other weekend and one night a week. I just can't do 2. And they lay it all out, right? And my client's like, that's bullshit. I want 50-50 now. She's not even saying I'm a bad dad.
Yeah.
Well, then we're going to have a discussion about, hey, if we don't get this deal today, you might not get your 50-50 for another 6 months. So take the deal now because you're going to get your ultimate goal sooner than waiting, because I'm not going to get into court for 6 months. And if she's withholding the children because she just can't emotionally detach those 2 days.
Yeah.
Right. Well, we all know it's going to end up 50-50, but sometimes you just take what you can get and you just move the ball forward.
Yeah, you can kind of see that there are two things going on. There's the emotional readiness for mediation, and there's emotional readiness for the specifics of living without your kids for 2 days. And those have to happen at their own pace.
That's right. That's right. And that's why a lot of clients will say, well, I don't have a choice. My lawyer told me it's going to be 50-50. And I'm like, well, you do have a choice. You can go to court. I'm just telling you we're going to lose, right?
Right. Right.
And I'm like, the law is not on your side in this hypothetical scenario. On the dad's side of my hypothetical, the
Yeah.
law would be on his side, right?
Yeah.
So you have to be emotionally ready to resolve your case.
But it's so. Let's talk just a little bit. Let's drill down a little bit on that. What do you do? What does the firm do? Whoever is involved in this process to help with the emotional readiness part.
Prepare.
It's really
Meeting
just
after
numbing your
meeting,
nervous system to being able to handle these questions.
like, listen, this is what's going to happen.
Yeah.
And I don't have any information in this case that leads me to believe that there's going to be a different outcome other than what I'm telling you.
Mm-hmm.
Now, I've gone to mediations. I just told them we're not agreeing to 50-50. And under Florida law, the new presumption is 50-50, as we well know by now. And I say, I understand there's a presumption. And I'm understanding that the only way, I want you to understand the only way that that presumption is going to be an enforceable court order is if the judge tells my client that's going to be an enforceable court order after a trial.
Right.
And I will tell them, you've looked at this information. I've looked at this information. We might view it different. We might view it the same, but that's where we are.
Okay.
Okay. Go ahead. I thought
Practical. I do. I have a quick practical question. You and I have talked before about trial, and you put me through the test of how to communicate in trial. And as a result, I'm now rude to everybody I talk to because I learned to shut up.
That wasn't really the result.
That's what happened.
You made it sound like you were never rude before that. I take issue with that.
Well played, counselor. Here's my question. You said that mediation is confidential. Do you do that same sort of mock coaching for communication, for how to present yourself at mediation that you do for trial? Is that something
Just the opposite.
Oh, see, this is interesting.
Just the opposite. This is your day to talk freely.
Okay.
Because anything we say to Tammy in
Can't
one room
be used against you.
That's right. Not only that, Tammy's not allowed to take it and say it in the other room until we give her permission to do so.
Okay.
So you speak freely. What you don't speak freely about is the actual offer you're giving. You want to be specific on the offer.
Okay.
When you're brainstorming ideas or saying how you feel or this is your concerns, those are all things that you should be just talking about at mediation.
Yeah.
The mediator and the lawyer may, which happens frequently, redirect you, might have you look at that from a different point of view to change perceptions, to talk about how things may or may not end up in court, to talk about, like, let me tell you, kids do not care when they're 2, 3, 4, 5 years old where they spend Christmas. They want the gifts.
Right.
Right?
Yeah.
Teenagers do not care about Mother's Day and Father's Day.
Mothers and fathers do.
Exactly. Okay. Yeah. So we got to talk about these different perceptions and the ages of your kids and what's really important. And you will have all these things that you're, oh, it's really important to them. And I'll tell them, I assure you.
It seems so much like the mediation process. Like we've talked often about how clients never get their day in court. It's their lawyer's day in court, right?
That's right.
But really your day in court is mediation. You get to bleed, right? You get to say, here are my issues. Here's what I'm struggling to process. Is that a fair assessment?
That is a fair assessment. But what you don't get is someone to tell you that the other side is wrong.
Yeah.
And you're right.
Right.
And that's what people want in their day in court. If I just tell my story, that governmental official, we put a lot of trust in them. The judge is going to tell me I'm right and he's wrong.
Yeah.
You don't get that at mediation.
You don't get that.
Because the mediator isn't the decider of fact, isn't the decider of law, is not going to tell you how this is going to end. You are the decision maker in what will happen. And Tammy will talk about this. Both parties, if they're going to settle, are going to feel uncomfortable in that settlement. So in preparation, I'm telling my client, here's where we want to be. We might end up here. You're not going to like it. I want you to get prepared to do something you're not going to like. I need you to be prepared to sign a document that basically you can go over the trash can and hurl and then sign it, and you're going to be okay.
Yeah.
That's the goal. No one walks out of mediation happy,
Feeling like they got everything they wanted.
because you won't, because you're going to have to compromise. And
Can
you
you
usually don't get everything you want in court anyway.
Yes, the last week's episode, we were talking about everything else, the E in the peace process,
Yes.
and you
Technically, the second E.
the
Babar.
second E. You're fair. It's good. Good catch. You talked about we were talking about like starting at the end of the divorce process and to determine the things that you want. Can you just refresh us for those who missed that episode? Just what is going on in that process? Because I think that gets to identifying your priorities and
Right.
what you're willing to be flexible on in mediation.
So on everything else, we always start at the end. We're going to end up with a final judgment. The final judgment, if you have kids, is going to have a parenting plan and child support. It's going to also have a marital settlement or an equitable distribution schedule. Alimony is going to lay it out in attorney's fees. So we're going to go straight through peace. So part of what we do is talk about goals of, hey, do you want to have a 50-50? Are you looking for, Memorial Day is really important to you. Is that one of your goals? What's your top 5? Do you want to keep the house? If so, why? Are you willing to go out retirement to do it? So we pull those goals out when we're preparing for mediation. How can we compromise on other items to get what we want on our major goals?
Keep those major goals up front.
Because what happens a lot, Pete, and I prepare my clients for this in meeting with your lawyer, realize when you've gotten your goals that, hey, I can let some of this other tier 2, tier 3, tier 4 stuff go. It's not as important as the main ones. And maybe you only get 3 out of the 5 of your goals on tier 1 because this is a compromise. You're not necessarily going to get them all. In doing that, though, I have a lot of clients, or just I should say it this way, a lot of parties going through this. When you solve one problem for them, they get to the next problem.
Yeah.
And then the next problem, and then the next problem. And you just keep going. And at some point, I've got to tell them the legal system is not going to solve all your problems. Yeah. It actually might create more than it solves.
Sure. What is it that, I mean, you've done a lot of these mediations. What is it that borks a mediation for your clients?
That just makes it go south and we're done?
Yeah.
Every client could be different. So think of every relationship is different and every trigger is different. The biggest things that make things go south is they're not prepared for mediation. They're not ready mentally to get their case resolved. They don't have enough information to settle. So on the finances, you got to be looking at your schedule of equitable distribution early. Are there documents you don't have that you might need? Are there reasonable assumptions you can make? Because you can spend a lot of money turning over every rock, but do you want to turn over every pebble? It's a client decision.
Yeah.
So not having enough information really is the hardest thing. Show up at mediation with an appraisal of the house. And if not a full appraisal, maybe you show up just with a realtor saying, this is what I would list your house out, a comparative market analysis, which is what they do when they go to price a house, right? They say, what are the comps?
Look at the comps,
and go from there. So have as much as that ready to go. And if you are like, I don't want to spend the money on a appraisal, are you willing to sell it and just let the market decide what that price is when you go to sell? So those are the conversations you should be having early on and keep your cases moving forward. But that's a big one to go south.
Do you have any like bucket lists, like, cocktail party stories of somebody who turned over a table?
Yeah, but it might have been me.
Okay. I think what we're getting at, and what I'm hearing from you is that so many of the things that you think you're going to do at mediation, you should already have internalized to the point that you're intimate with where you are before you get to mediation.
Right.
That's the homework.
That's the homework. That's the homework. And in the perfect world, the other side's prepared too, and it can go fairly quickly.
Yeah.
But mediations are usually set for half day or full days, which is 4 hours or 8 hours.
Yeah. It's a long day.
I've had mediations start at 9 a.m. and go till 1 in the morning.
It's a long day.
Yes. So, but that's because one of the parties might not have been emotionally ready to make this
Yeah.
happen, right?
So is the answer when things happen at the end of those long days that they're just exhausted to the point of
No.
figuring it out? You don't think they ever get to
No,
that point?
because they do, but what happens is if it's the longer it goes, first off, we always order lunch and we always order dinner because people have to get fed and you got to,
Yeah.
you know, but
And you want to keep them there, right?
you want to keep them there as long as you're moving the case forward towards a real resolution or
Yeah.
a partial resolution. You don't stay there just to stay there. That no one wants
Right.
to do that.
Right.
But what you do is keep moving the process forward. And maybe you just get a partial agreement. Maybe you get an agreement that's going to happen for the next 3 months and we're going to come back to mediation. Maybe we get an agreement that we're going to do a joint appraisal and we're going to have more information, but this is how we're going to move the case forward. That's a very productive mediation if you can set some goals on how you're going to in agreements on how you're going to move the case forward.
Yeah. Right.
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 So with all that's success. And they're like, oh, I was really hoping to get a parenting plan, really hoping I would be able to sell the house by now. And I'm like, look, we've moved forward. Right now, what I do is I am happy to set another mediation, but I always ask for an impasse of the mediation. And what that means is, Judge, we've tried. We didn't get a resolution. I got an impasse. I'm allowed now to go to court. If I continue the mediation for 3 months, I'm now 3 months behind in the court system.
Right. Which could equate to 9 months behind.
That's
setting
right.
a date.
That's right. So I will get my impasse and then I'll say, look, I'll still work with you. But look, we're working well together, but I can't guarantee you're going to be the lawyer there in 3 months.
Yeah.
You know, shit happens.
Right.
You get fired. Something happens. So let's move that along.
Okay.
So the other thing that I think you're really picking up on, Pete, is people will be so nervous going into mediation, but part of their nerves is they don't know what's going to, the final deal is going to be that it might happen that day. Right.
Yeah.
And so what I tell them is the worst thing that happens today is we walk out of here in the same position we walked in without a deal. That's the worst thing.
It's not going to get worse for you from where we start.
Right. We got a litigation plan. We're going to go through all that crap. But yes, that's the worst where we are right now, because nothing gets signed at mediation without your agreement.
Right.
Now, what happens is people will sign, and I prepare my clients for this. You're going to sign a document, and the next day you're going to have buyer's remorse. Because the next day you're going to think, I should have fought for that more. I should have thought for that. In a month, 2 months, everyone talks about, man, I gave away too much because they compromised beyond their comfort level, but it was a better decision than going to court. I should have settled with Seth for 75 grand. Right?
Yeah.
Like, or if you sign that deal with me and you're like, the next day you're like, I really could have gotten 95 in court. I should have not given up that extra 20 grand to Seth. Well, guess what? You have had to pay for the privilege of going to court. Like, you forget about all the bad stuff that was about to happen and the stress and the money and talking to lawyers and going to depositions and going out with your friends and having this take up the space in your head, as opposed to going out with your friends and enjoying the evening.
And yet I have to ask, what does the scenario look like when someone's buyer's remorse is so strong that they feel like they have to undo what they did at mediation? Is it just a no take back situation or
no? So there's takes backs. It's hard. You have to say that you're under duress, that And so what happens if my client does that and they say, Seth, we got to file a motion to set aside this agreement. I was under duress. I couldn't do it. I said, I appreciate that that's how you feel, but you have to get another lawyer to do that because now we're in conflict.
Okay.
Because I am not going to let a client sign if I believe they're under duress. And I've pulled mediations. I've ended, I said, to the mediator, we're at an impasse.
Yeah.
No, they'll stick. I said, my client is not emotionally ready to do this.
Yeah.
I cannot, in good faith, have them sign a document right now. And I'm saving everybody trouble because if they sign it, you're going to get a motion to set aside. And I'm going to have to tell the judge, I'll have to get attorney-client privilege waived to say, Judge, I advised them not to sign it because they were too emotional and I thought they were under duress.
Yeah.
But they didn't take my advice and they signed it anyway. But from my professional opinion, this should be set aside.
Here we are.
I'm going to have another lawyer make those arguments. I'm going to end up being a fact witness on that one.
Does another lawyer take it straight to court? Is that the next step? You were under duress. Now we're going to skip any other mediation. We're just going to court.
Unless the judge orders you back to mediation.
Yeah. Interesting. Okay.
Right. Or maybe you're taking depots. Take another mediator. Mediator files a protective order. Everything's confidential.
Yeah.
You go to court to say, Judge, we need the mediator. Right. So it's a great question.
How often does that happen?
I'm never surprised when someone calls me and asks me to say they were under duress at mediation. My first question is, who's the mediator?
Okay.
And if it's Tammy, I'm thinking we're losing that one because Tammy will say, I'm not presenting this because she's got a duty to watch out for that as well.
Yeah. Interesting.
Yeah.
Anything else in the bucket we should be talking about before we actually have our conversation with Tammy next week? What have we missed?
On the preparation, if you're not good with numbers, if they scare you, if you freeze, right? Make sure you review all the numbers on values. Make sure you understand how the schedule works of equitable distribution. Understand where your money is being spent for your alimony analysis. Understand with your lawyer how the child support guidelines work and how different incomes impact that, how the taxes work. So it's a lot of math. So you got to get comfortable with those numbers and ask your lawyer, how long should I be there? When I talk about being prepared, be prepared to be there late and have childcare. Who's picking up the kids from school? Can someone
going to make sure they're fed? Yeah,
that's right. Dress comfortably. You don't have to be in a professional attire. It's a mediation. No one cares. Dress comfortably.
Okay, that's good. I feel good about this. I've learned a lot. Look at you.
know.
I'm ready. I think I'm ready for mediation next week.
Well, the way you and Andy were talking before the show started, I thought I was going to have to put back on my mediator hat when I used to meet.
You can be so mean sometimes.
And I can't take sides, but you're right.
Yeah. We have a listener question today, Seth.
Oh, nice.
Listener question comes. If you have a question, please, we'd love to hear it. howtosplitatoaster.com. There's a submit a question button right there. Click it. Ask your question, just like Fed Up with Frivolous Motions did.
Nice.
If spouse is not willing to mediate or settle at all unless I give in on this unreasonable request, i.e. nothing equitable, or 50-50, 100% his way, but he also tries to delay the trial by endless motions of issues and discovery requests, how can I make my lawyer or judge stop his frivolous behavior? My lawyer keeps on saying he has a right to do so. Mental health and money are all at stake here. Thank you.
Great question. So on that one, your lawyer's saying they have a right. So check your local jurisdiction. When I start getting a ton of motions and I'm having trouble getting the court to set a trial date, and not because it's just 6 months out, 9 months out, and that's the first date. Like when I'm trying and the other side's objecting that we're not ready for trial, I will do a motion for scheduling order.
Okay.
And what that is judge, here's when discovery needs to be done. Here's when it all has to happen. Here's deadlines to do witness lists. Here's deadlines to do expert lists, witnesses that you might have. but let's put this on a time frame, and let's do our absolute best to hold to this time frame.
Sure.
Because then it's not just, well, I filed a motion or I filed a request to produce. They've objected. Then you got to set it for hearing. Like as long as you can keep moving it along. And we've talked about the process at the court system, how you file a motion, you got to serve it, or it goes to the other side, and then you got to set it for hearing. And it's 30 or 60 days, and then a hurricane hits and it gets continued, or someone gets sick, or whatever that might be. So with all that being said, I would talk to your lawyer about, can we get a trial date and work backwards? Judge, we need a trial. They're going to say we're not ready for trial. Then we're going to say, well, let's get a scheduling order so we can get ready for trial.
Do the what, let's just say in this case, what Fed Up is saying, do the frivolous motions from their perspective stop after a trial is scheduled? Or is that potential ammunition in this process?
It still is. If they're truly frivolous in the legal term, as opposed to you just feel like it's harassment, right? No, they might still happen, but there'll be more deadlines. Okay. And deadlines, back to preparation, bring settlement, because a deadline is pressure.
Yeah.
Nobody is worried on the first day of college when they get their syllabus and the papers due 9 weeks from now. No one's stressing.
No one's stressing about that paper.
Yeah.
Right.
Yeah, go talk to them that weekend before, and it's due on a Monday.
Yeah.
Brings pressure. Deadlines bring pressure. Pressure brings movement. Movement brings settlement.
Outstanding. Well, Fed Up with Frivolous Motions. I hope that that helps answer the question.
The best title of a listener question we've ever had.
Keep them coming. Keep them coming. Thank you for submitting that question. Thank you all for submitting questions. We like to hear them. We like to answer them on the show. We appreciate more of them. howtosplitatoaster.com is where you do that. Thank you for today, Seth. I've learned a lot. Looking forward to next week.
Oh, it's going to be great.
It's going to be great. We love Tammy. And thank you all for downloading and listening to this show. We appreciate your time and your attention. On behalf of Seth Nelson, America's favorite divorce attorney, I'm Pete Wright. And we'll see you next week right here on How to Split a Toaster, a divorce podcast about saving your relationships.